We've got two major developments in the case pending before Judge Boesberg about whether Donald Trump and his administration violated the Constitution and violated United Nations protections against torture by deporting people after kidnapping them, not giving them any due process, and sending them off to the deep, dark recesses of an Salvadoran jail. Two major developments I'm going to cover here on Legal AF. One, we've got the final piece of paper filed by the plaintiffs representing the class of people subject to these deportations, these unconstitutional deportations, and they are arguing for a preliminary injunction to stay in place throughout the remainder of the case because they are going to win. I'll talk about that. But earlier in the week, or earlier before this brief was filed, we had a very hot bench coming out of Judge Boesberg, who cross-examined, I think, to within an inch of his life, the lawyer Drew Ensign for the Department of Justice in a hearing about whether he was going to find the administration in contempt. I'll talk about that hearing and what if the judge does find, and I think he will, find the administration in contempt. What does that mean in terms of a remedy as I bring these two stories together, one place, Legal AF. Let's get to it. Judge Boesberg has been presiding over this case for over 3 weeks. It was 3 weeks ago today, on this Saturday, that the judge at about 6:30 in the evening issued an order, a temporary restraining order, stopping, in his view, all continued deportations to El Salvador without notice, without due process, so that these people could claim whether they were or were not members of a criminal gang or terrorist gang or not. Also, the judge said, I don't think that President Trump has properly invoked his war powers under the Alien Enemies Act. But there was a violation of this order almost immediately. Planes with people continued to be deported in a way that appeared to the judge to be in direct bad faith contradiction and violation of his order, done purposefully. And that was the focus of this hearing I'm going to tell you about. Then we also have the new filing, which is the last piece of paper the judge is going to accept to decide whether he's going to make his injunction permanent. And a new argument that was raised during the injunction proceeding about whether the UN Convention Against Torture and other types of punishment, which is known as CAT, C-A-T, whether those conventions were violated and therefore gives another right of action for these people who were deported without due process. I'll break it all down right here. Let's dive into the hearing first. People forget, at least the Department of Justice didn't seem to know, that Judge Boesberg, before he became a judge, was a pretty skilled prosecutor back in the day and knows how to cross-examine a witness to within an inch of his life. That witness was Drew Ensign, the lawyer for the Department of Justice, who spent an hour being grilled and roasted by Judge Boesberg, who was not happy. The nature of this hearing was whether the judge is going to impose contempt sanctions for finding a willful bad faith violation of his orders by the Department of Justice, who did not return the planes, who did not turn the planes around, who continued to deport pursuant to an enjoined and blocked use of the Alien Enemies Act. And the judge is not happy. This is what federal judges in black robes, we call it the black robe disease. When they're not happy, nobody's happy. Now, let me contrast this for 1 second. We've got another judge, Judge Zinnes in Maryland, who yesterday found the Trump administration similarly acting in bad faith and had committed an illegal act by deporting a person who they knew, should have known, they knew was protected by an asylum order of an immigration judge in the United States. And yet they deported him knowing that to El Salvador and then claimed they couldn't get him back. Judge Zinnes has ordered the return of that particular plaintiff, the one that the public is all up in arms about, from Maryland, Kilmer Abrego Garcia. He must be returned to the United States on Monday, according to Judge Zinnes. Now we got almost the same day, within 24 hours of each other, Judge Boesberg, he's got another lawyer in front of him for the Department of Justice. And here's the nature of the grilling. He says to the lawyer, first of all, I take it you think your position is that the government complied in good faith with my order. Is that your position? Yes. And then he proceeded to tell him how that couldn't possibly be true. He said, all of the things that you did, the president signing the proclamation under the Alien Enemies Act, but not publishing it to the public until the following day. In the meantime, loading up planes, getting the logistics ready, speeding up the process. Once it was clear that a lawsuit had been filed on early Saturday morning, 3 Saturdays ago, with a judge holding a hearing later that afternoon at 5 o'clock. All of that while you're continuing to load the planes, that does not look like to me somebody who's operating, believing that their actions are lawful and will ultimately be affirmed by a court. It looks like somebody who's acting in the middle of the night and in the dark to try to avoid a court jurisdiction. Would you not agree with me? I mean, from there it went downhill for Drew Ensign. He said, now, I gave you an order, an injunction in court at 6:37. Who did you tell? I told you to tell everybody that was responsible concerning the continued flights and the logistics of getting people out of Texas and into El Salvador. Who did you tell? Now, the answer should have been, I told the the Secretary of Homeland Security, Kristi Noem, the Secretary of State, Marco Rubio. I told the President of the United States, Donald Trump, and I told the Department of Justice, Pam Bondi, and the people that were under them. Instead, he said, we told somebody at ICE, we told somebody in Homeland. Like, this is not good enough for a federal court judge. So Ensign already screwed up because I don't think he told the right people. He said, okay, so those are the people that you told? Doesn't seem to be the right people. All right, let's move on then. He said to him, now, the government won't give me the information that I'm demanding about the flight information. Who, what, where, why, and how of the flights. Is that right? Yes. Are you taking the position that that information is classified and can't be shared with me, at least in private in my chambers? No, it's not classified. All right. So then cite for me one example in the entire history, in the entire last 90 years or 80 years, in which the state secrets privilege, which your client is claiming applies here, has been applied, state secrets to unclassified information. I'm waiting. And then Ensign couldn't really answer it. So the judge answered it for him and said, it's pretty sketchy, don't you think? That's a pretty sketchy response. That's a stretch. So what's going to happen? The judge is going to find that they improperly invoked the State Secrets Act in order to put the judge in the dark and not let him know about the illegal deportations without notice. Obviously, he's going to find that Ensign either purposefully or unintentionally or intentionally failed to properly advise all of the aspects of the government. That's a bad thing. And he's going to find that the government willfully and in bad faith did not follow his order. So what's the remedy? Because he's going to come out with a contempt decision in the next couple of days. You'll come back here on Legal AF. I'll tell you all about it, but it's coming. It is obvious it is coming. And then what's the remedy? Like, what can a judge do at that time? So let me tell you what that can be. In a normal civil case, a judge could fine dollar amounts a party that's in contempt. 1,000, 5,000, 10,000, 100,000, $1 million a day until there's compliance. The problem is they've already flown the coop. They've already flown these people from Texas to El Salvador. He could try to order that they all be returned a la Judge Zinnes in Maryland when it came to Abrego Garcia. I'm not sure he's going to do that. He could do that. And this could all be either or, a combination of things. He could also strike the government's defenses in the case, impose the preliminary injunction I'll talk about next, and tell them they've lost the right to contest, and he's going to rule against them. I'm not sure he goes that far and finds them effectively in default and enters a default judgment against the government on this major issue, because I think he wants a clear record as it goes back to the D.C. Court of Appeals and then up to the United States Supreme Court. But he could. We've seen judges do similar things. When Judge Beryl Howell in D.C. did not like how Rudy Giuliani was conducting himself in court and how he violated 8 or 9 different court orders, she eventually struck his defenses and entered a judgment against him on defamation in the Ruby Freeman and Shay Moss case. And that's how we got to it. And then a jury's the one that allocated the $158 million, but she found on liability as a default sanction. So judges have the power to do that, and they are upheld. I'm not sure if Boesberg goes that far. I think there's going to be a monetary fine. I think he's going to order people to appear. I think he's going to order somebody to come back. I think he's going to, like I said, a dollar amount, and he may do something. He's going to enter the preliminary injunction. That's the next step up, right? Administrative stay. Next step up is temporary restraining order. Next step up is preliminary injunction. And the only difference between all those three things is time, temporal, how long they last. Administrative stays, a few days or hours. Temporary restraining orders, if they're granted, a week or 2 or 3 or maybe a month. Preliminary injunction from that moment all the way to the end of the case. All the way to the end of the case. And each time the judge is evaluating the merits of the case. So let me get to the merits of the case. That's the contempt hearing. Let me move to the preliminary injunction. On the preliminary injunction, the final brief is in, and what they're arguing is the following. And this is from the ACLU, the American Civil Liberties Union, and they are right. That the argument that the government is making that only a habeas corpus petition, which is to bring the body out and release it from jail, is the only way to challenge this Alien Enemies Act proclamation is just wrong. That a judge sitting in equity has powers under the Administrative Procedures Act combined with his own inherent equity powers to order things like, agency, you stop following that proclamation. So one, the court has power through its inherent authority, its equitable power, and the Administrative Procedures Act. The second argument, which is the right one, is that anything that the president does under the Alien Enemies Act, or under his war powers, is reviewable by a federal judge. Yes, of course. It's not martial law where he suspended the judges and suspended the court system, heaven help us. Judges in our co-equal branches of government and separation of powers, check and balance, have a role. And reviewing is part of that role. They later say in their brief, and we're going to win, that he improperly invoked the Alien Enemies Act by proclamation because there's no war. But fundamentally, judge has power to fashion a remedy, has jurisdiction over this issue and over the people, and has the ability to review the judge's, Donald Trump's actions. Then they make the argument on the merits, which I'll read to you just briefly, because I think it's that important. Let me just turn to page 15 for a minute. So here we go. On Article 2, they make an argument that Article 2 of the powers of the presidency give him the right to summary removal of people without due process. And their argument is that whatever the process is that the president says, that's due process, and it can't be reviewed. See how it sort of eats itself? It's sort of a catch-22, and it's easy to undermine this argument. So they say in there that there is that the executive branch has to have it be reviewable. And ultimately, the problem with their argument is there is no war. The Tren de Aragua narco gang is not a nation or a government. It's not a predatory incursion. It's migration and immigration at best. And you can't declare a war against Venezuela and then call them enemy combatants to blindfold them, kidnap them, and send them out without due process to El Salvador. And that whole action violates the UN convention that we're a party to against torture and other punishment. It's called the CAT Convention, and that's been violated, and they need due process to be able to invoke that. Look, here's what's going to happen. Judge is going to enter a preliminary injunction. Last thing to keep an eye on. We are still waiting for the United States Supreme Court to decide whether on the temporary restraining order, on the temporary restraining order, the original order is going to be kept in place until the preliminary injunction. He's hearing the oral argument on the 8th of April. It's right around the block. They're not going to rule that he can't hold that hearing on the 8th of April. in general, courts like the Supreme Court want full records developed at the preliminary injunction stage. And so they're going to allow him to make his ruling. It may not survive 2 more levels of appellate review. I think it will, but that's what they're going to do. So I'm not worried about the Supreme Court stopping Boesberg in his tracks right now. They're going to stop him. They'll stop him a month from now, but not right now. In the meantime, that use of the Alien Enemies Act is blocked. That's why we don't hear more about deportations pursuant to it while it's in court. So we don't yet have another violation by the feds of the court order. They're complying. They're obeying for now. I'm Michael Popok. You're on Legal AF, the YouTube channel. I'm Michael Popok, and I got some big news for our audience. Most of you know me as the co-founder of Midas Touch's Legal AF and the Legal AF YouTube channel, or as a 35-year national trial lawyer. Now, building on what we started together on Legal AF, I've launched a new law firm, the Popok Firm, dedicated to obtaining justice through compassionate and zealous legal representation. At the Popok Firm, we are focused on obtaining justice for those who have been injured or damaged by a life-altering event by securing the highest dollar recoveries. I've been tirelessly fighting for justice for the last 35 years, so my own law firm organically building on my Legal AF work just feels right. And I've handpicked a team of top-tier trial fighters and settlement experts throughout all 50 states known as big auto injury attorneys who have the know-how to beat heartless insurance companies, corporations, government entities, and their attorneys. Big Auto's attorneys working with my firm are rock stars in their respective states and collectively responsible for billions of dollars in recoveries. So if you or a loved one have been on the wrong side of a catastrophic auto, motor vehicle, rideshare, or truck accident, suffered a personal injury, or been the victim of medical malpractice, employment harassment or discrimination, or suffered a violation of your civil and constitutional rights, then contact the Popok Firm today at 1-877-POPOK-AF or by visiting my website at www.thepopokfirm.com and fill out a free case evaluation form. And if we determine that you have a case and you sign with us, we don't get paid unless you do. The Popok Firm, fighting for your justice every step of the way.